Well, welcome everyone. Thank you for joining us today for our monthly webinar. My name is Natalie Higgins and I'm General Counsel for the Equipment Dealers Association. Our presenter today is Kathy Robinson. Kathy is a benefits advisor for the Employee Benefit Security Administration. Kathy's group, EBSA, is responsible for educating and assisting employees and their families who are covered by benefit plans in the United States. Their goal is to increase the knowledge of plan participants and beneficiaries, plan sponsors, service providers, and other interested parties, and to make sure that these people have access to their plan documents. Before we get started, I'd like to run through some basic housekeeping. This and other webinars are free services of the Equipment Dealers Association to our dealer members. The Equipment Dealers Association serves its members by advocating in Washington, D.C., and by providing industry relations services such as contract reviews. Here at EDA, we don't charge extra for webinars, but we are funded by your dealer dues. If you haven't done so already this year, we encourage you to renew your EDA membership to help ensure that EDA can continue to provide these valuable services. If you renew by July 31st, 2017, you can take advantage of a terrific offer exclusively being offered by Machinery Pete for EDA members. Machinery Pete will take 20% off of your first email marketing order if you renew your membership and sign up for these services by July 31st. So get signed up as a member of EDA, sign up for your Machinery Pete services, and make sure you don't miss out on this fabulous deal. For today's webinar, we will take some breaks to respond to questions. As we go through the slides, feel free to type in your questions. We will review them and either answer them live, or if it's a very specific question, Kathy may follow up with you after the webinar to answer your question. Finally, a link for this webinar and the webinar recording will be emailed to you in case you'd like to review it later on or share it with others at your dealership. For EDA members, be sure to remember that you also have the EDA legal hotline available to you if you have follow-up questions pertaining to your dealership practices. If you do have follow-up questions, please feel free to reach out to me. And that's all I have as far as housekeeping. So with that, I will turn it over to Kathy.
Great, thank you, Natalie. Like Natalie said, I'm Kathy Robinson. I'm a benefits advisor with the U.S. Department of Labor, Employee Benefit Security Administration. I've worked here about 10 years in this capacity. I'm also an attorney. I've been an attorney about 22 years and a mediator about 21 years. And I find all of that to be very helpful in the work that I do here, both educating plan sponsors and fiduciaries and participants, as well as trying to resolve disputes that participants sometimes have with regards to getting their private employee benefits. My contact information, my phone number is 816-285-1874, and my email address is Robinson, R-O-B-I-N-S-O-N Kathy with a K-J, that's K-A-T-H-Y-J, at DOL.gov. We also have a toll-free number, that's 866-444-3272. And as you can imagine, there's lots of times that I'm away from the phone or on other calls or working on other things, such as giving presentations or traveling. So your best bet is to call the toll-free line. It's open 8 to 4:15, Monday through Friday, that's Central Time, and usually calls are answered within a minute, and you can get an immediate response to your question. With regards to the presentation, this one's a little bit challenging because there's 4 topics that we're covering in 1 hour, and they're all pretty big topics that could easily be 1 to 4 hour or even 1 to 2 days presentations just among themselves. And that's fiduciary duties, plan documents and notices, what we call disclosure requirements, what to expect from an EBSA investigation, and the voluntary fiduciary correction program. I'm going to go over just a few housekeeping items myself. One is, I realize I talk a little fast, but I try to make it as accessible and clear as possible, and I try to signpost where I'm at and where I'm going. So usually people do find it to be fairly easy to follow me. Some of the sections that we're going to go over overlap just a little bit. What I tend to do in setting this up is provide fairly comprehensive information in the slides, given the parameters of what we're supposed to cover and the time limits. And I don't necessarily go over every slide, or some slides I just gloss over, depending on how important they are or how self-explanatory they are. When that happens, I'll try to be very careful to let you know what I'm doing. The first section is the most important section, so I will go over every slide pretty comprehensively. The rest of the 3 topics I won't go over as in-depth as the first topic. I'm not sure how experienced each of you are with group health plan issues and responsibilities, and so the information that I provide goes from very basic to some fairly sophisticated concepts. Let's see. One other thing I was going to say is, since you don't have the PowerPoint yet, you might want to tailor your notes to the slide number so that it's easier for you to put those together. I'm going to be talking about these topics, and for each of these topics, we have publications on our website that are available. I'm going to tell you a little bit about these publications as they fall within the presentation, and you are welcome to find these publications for yourself on our website. But frankly, the way that I find the publications, and the easiest way to find the publications, is to Google it, put EBSA, comma, and then the title of the publication. But there's also another option, which is of the 4 publications that I'm going to talk about. You're welcome to email me if you'd like to request one or all of the presentations. And if you do email me, reference this presentation, include your name, company, the address you want the publication sent to, your phone number, and identify the publications that you want. Okay, let's get started. The publication that we have that goes over the first part of the presentation is called Understanding Your Fiduciary Responsibilities Under a Group Health Plan. And that's a segue into our first section, which is what it means to be a group health plan fiduciary. I said that the first part is the most important part, and basically these slides are the nuts and bolts of fiduciary duty, so all of them are pretty important. Tips for avoiding common problems for fiduciaries. This slide is a very important slide. All the information is very important. Carefully select and monitor service providers. Make required disclosures like notices, etc., to participants and beneficiaries. Understand your plan and your responsibilities. Make timely contributions and monitor plan assets, and file reports with the government and keep good records, which is what we call record keeping or reporting. What is an EBSA group health plan? To be covered by EBSA, it's a private employer or union-sponsored employment-based plan that provides coverage for medical care, hospitalization, sickness, prescription drugs, vision, dental. The plan can provide benefits through insurance, which we call fully insured, or be self-insured. And with the self-insured plans, benefits are paid from the employer's assets or from a separate trust. What is an EBSA fiduciary? Any person, this is also a very important slide, any person who exercises discretionary control or control over plan assets or administration or gives investment advice for a fee. EBSA has a functional definition, not dependent on job title or documents. So someone who either is supposed to or somehow inadvertently or in a unique situation exercises discretionary authority or control over plan assets or administration or gives investment advice for a fee is an EBSA fiduciary. So it's not based on we are the attorney in the matter, or we're just a secretary in the matter, or I just am an employee in HR and therefore I'm not a fiduciary. If somehow the actions of that party rises to the level of or goes into the realm of someone who ends up exercising discretionary authority or control over plan assets, then that person can become a fiduciary. And a fiduciary is any person named as the plan fiduciary in plan documents, or, like I just said, someone who exercises discretionary authority or control over plan management, or exercises authority or control over plan assets, or provides investment advice for compensation, direct or indirect. A fiduciary must not act in their own self-interest, act on behalf of a party with adverse interest, or accept anything of value from those doing business with the plan, like kickbacks. So why is it a big deal whether or not someone is a fiduciary and what they do? The consequences of failure to fulfill fiduciary duties. There's personal liability to make the plan whole. You wouldn't go to the business to make the plan whole. There's personal liability, outages, and give up any gains or profit. The Department of Labor may sue and also may assess civil penalties, and the fiduciary may be removed and barred from being a fiduciary in the future. Basic fiduciary duties under EBSA. And this is slide 8, and this is also a very important slide. Basic fiduciary duties: to act solely in the interests of the participants and their beneficiaries, to be prudent with care, skill, and diligence, to pay only reasonable and necessary expenses of the plan, to follow the terms of the plan and documents governing the plan, to hold plan assets in trust or with licensed insurance companies. Okay, so that is the most important part, not to suggest important. They're certainly important in their own right, but in terms of knowing the basics and understanding what it means to be a fiduciary and what it entails, that's the most important part of what we're going to cover today. But we're going to move on to part 2, which is basically disclosures or providing notices and documents to plan participants and beneficiaries. Okay. Probably the most important document in any employee benefits plan is the summary plan description document. Everything that's required to be in it. It also must be written to be understood by the average plan participant. Who gets a summary plan description and when? This must be furnished automatically to participants within 90 days of being covered by a group health plan. Must furnish the current summary plan description within 30 days of a request. And I just want to let you know, whenever we say request in one of our presentations, we always mean written request. That's not to say that a plan can't respond to a verbal request, but they only have to respond to a written request. But they have to do so and provide that disclosure that's requested within 30 days of the request. Generally, the summary plan description must be redistributed every 5 years. What if the plan changes? Then it's going to be quicker than every 5 years. You must distribute a summary of material modifications, also known as an SMM, or an updated summary plan description, if there are material plan changes or changes in the information required to be in the summary plan description. No later than 210 days after the end of the plan year, and if it is material reduction in covered services, no later than 60 days from the date the change is adopted. Now, we're going to touch very briefly on something called the summary of benefits and changes. And I just want to point out here a distinction between when a summary of material modification has to be supplied versus when information in a summary of benefits and changes has to be sent out. Notice that on the summary of material modifications, there's some pretty late time frames where people don't necessarily get advance notice. It says you have to provide an SMM no later than 210 days. That's a long time after the end of the plan year. So not even necessarily after when the change was made. It could have been made at the beginning of the plan year. And you let them know within 210 days after the end of the plan year. But if it's a material reduction in covered services, no later than 60 days from the date the change is adopted. If the change is adopted and immediately goes into effect, people may not know and be adversely affected by the change until about 60 days after the change goes into effect. However, in the summary of benefits and changes, which came about under the Affordable Care Act, for certain kinds of changes to the plan, which we won't go into because that's going to be too specific here, you have to give advance notice of certain kinds of change. So just to let you know, those are some things to keep the deadlines in mind of, and realize that sometimes you have to give advance notice, but sometimes you don't have to give advance notice. More automatic disclosures. The summary annual report, known as the SAR. COBRA notices. This is one that businesses, especially if there's a lot of turnover or even some turnover, are going to typically be most familiar with, is their obligations under a COBRA notice. Although we do have calls sometimes where employers have no idea what COBRA is and no idea that they are to issue a notice and no idea how to do that. And while surprising, we're certainly happy to help in those circumstances to get them the information they need, the publication that tells them how to do it, model notices, etc. And one thing to point out that I try to point out is there are a lot of situations where callers are participants and they have problems getting benefits that are due to them, and we engage in informal resolution to try to help resolve the situation or get them the benefits or what have you. But we're also here for employers and plan sponsors and fiduciaries as well. And we certainly get a lot of phone calls along those lines. So if you're a fiduciary or you're an employer and you're not sure of your role or who does what or that you're doing something correctly, by all means, feel free to call our toll-free line because we're certainly here as much for employers as we are for employees. Other automatic disclosures, HIPAA notices, Part 7 of Title I of EBSA. I'm going to go over a little bit more specifically later, the HIPAA Part 7 notices. There are a bunch of laws that fall under the HIPAA Part 7, and so I'll list those laws for you, some of which you may not have heard of, some of which I hope you have heard of, but each of those have notice requirements. And I'm going to go over easy ways for you to know what those notice requirements are. And sometimes there's even sample notices. And then notices and disclosures in connection with claims for benefits, like an explanation of benefits or an adverse benefits determination, which we call a denial of a healthcare claim. Okay. Disclosures on request. Upon receipt of written request, the plan sponsor or the fiduciary or the plan administrator must provide the plan document, which some people think is the summary plan description. It's the underlying document. The summary plan description is a summary of that document. They need to provide the current SPD, insurance contracts, other instruments under which the plan is established or operated, such as the trust agreement, the Form 5500 or the Form 5500 short form, which is the reporting document that is required in most cases to be filed with the Department of Labor. And then there's miscellaneous disclosures, which I will give you resources to help you know what those are and what they apply to. How to furnish documents. This is an important slide because of the third option. Well, it's important in its own right, but because of the third option. In-hand delivery at workplace, by mail, electronic delivery, like email, subject to certain regulatory standards, but posting in a common area is good to do to be helpful, but it is not enough to establish that you furnish that document. Now, electronic delivery is too complicated and specific for me to go over right now, but I just want to tell you, you can't just send things out by email to their home or to their work email typically and expect that that is going to be sufficient furnishing. In some cases it might be, but in many, many cases it's not. And then they also have to consent to that, or they can revoke allowing you to do it electronically. But there's certain requirements like using a computer. If you're going to send it to their work email, using a computer has to be a regular part of their work that they have access to, etc. So I would recommend that if you want to use electronic delivery, you need to look at the regulations, you need to look at information on our website, or you can call a benefits advisor. But it's not as simple as, it's not necessarily intuitive or common sense. You've got to know specifically what's okay and what's not okay. Okay, so what happens if you fail to provide documents that they've requested? Civil penalties may be imposed for failure to provide timely a current summary plan description, the instruments under which the plan is operated, the COBRA notice, or the HIPAA notices that I mentioned before, Part 7, Title I of ERISA. It sounds a little arcane and maybe a little bit legalese to say Part 7, Title I of ERISA, but it's a helpful way, once you get that under your belt of a way of looking at HIPAA and all those laws, it's a nice way to use a little phrase that conveys what you're talking about or what you're meaning. So put that in your repertoire of ways of talking about ERISA. It's worth the trouble of something that doesn't naturally fall off the lips. Okay, the big one here is like a COBRA notice. People will call us to get a COBRA notice, and they'll say, you know, it's 2 months late, what can I do? Well, our office doesn't really do anything to an employer if they don't provide the COBRA notice timely. If they haven't provided it yet, we ask them to provide it. If they provided a defective COBRA notice, we ask them to provide an accurate COBRA notice. But the participant can take the employer to court and ask a judge to give them $110 a day for every day that it's late. So there are some civil penalties that might apply by not giving notices timely. Okay, this next slide I consider to be very important because it is a list of the helpful publications on our website. And right there is our website. So the first publication is Health Benefits Coverage Under Federal Law Compliance Assistance Guide. This is an extremely helpful publication that we make available for a couple of for lots of reasons. But one is there is a self-compliance tool for Part 7 of ERISA, which is the HIPAA laws, healthcare-related provisions. So if you want to know, to some degree, if you're doing the right thing under your plan, because sometimes people aren't confident about that, then you can go through this self-compliance tool. Am I doing this? Am I not doing this? Do I follow non-discrimination? Is my wellness program doing what it's supposed to do, or am I in violation of what's not okay to do? What's also extremely helpful in this publication is that it has an appendix of a chart of required notices. And it goes through and it says, notice of special enrollment rights, wellness program disclosure, the Women's Health and Cancer Rights Act annual notice, the Women's Health and Cancer Rights Act enrollment notice. So it goes through every single notice required under Part 7 of HIPAA and all of those different laws. And then there's another appendix that has model notices. So basically, if you can use the notice word for word in our model notices and make sure that you're complying with what the law requires you to do under ERISA. So this is a very helpful publication. The next publication is Reporting and Disclosure Guide for Employee Benefit Plans. This includes not only group health plans, or welfare plans as we call them, but also pension plans. And of course, for today's purposes, I'm only going to talk about the group health plan ones. But it talks about the document that would be disclosed or provided, we call it disclosure, when it's due, what's in it, who gets it, and it gives you a list of all the different types of documents that would be notices or otherwise required to be disclosed. And so that is also a very helpful publication. Okay. And then there's also a fourth publication that I did not put on the list, but you can also request from me. And this is called the Voluntary Fiduciary Correction Program. And it's a publication that talks about the Voluntary Fiduciary Correction Program, which I'm going to talk about briefly as the last portion of the presentation. One final thing that I want to say about this is, how do I say this tactfully? We got a new website recently, and some of us are struggling, some of us who work with it every day and do this every day and know it pretty well, I hope, are struggling to find things on our website that we used to just know very easily. We could go to like a COBRA notice or an employer's guide to continuation coverage under COBRA or what have you. They're not as simple to find as they used to be. So what some of us do is we Google it and we put EBSA, which stands for Employee Benefit Security Administration. So we put EBSA, comma, and the name of the publication. And it pulls it up on the website, and that's a simple way to get what you're looking for. Okay, so we are now done with the first two sections of the presentation, and we'll move on to the third one. The third section of the presentation is basically what to expect from a health plan investigation. And this is one where it does overlap a little bit with what we've talked about already, but I think for comprehension purposes and fluidity of understanding what to expect from an investigation, it bears repeating and helps make it as understandable as possible. A few basic things a group health plan must have. The governing plan documents must comply with ERISA. In a lot of ways, plans get to make their own rules, and they get to decide what they cover and what they don't cover, and what they don't cover, unless the law requires that they cover something or cover it in a certain way. Otherwise, they pretty much get to decide what they cover and how they cover it. However, all of the plan rules must comply with ERISA. You can't not cover something that's required by ERISA or do so differently than is required under ERISA. If the plan document conflicts with ERISA, then of course what is said in ERISA is going to trump over inconsistencies in the plan documents or the plan rules. The group health plan must have a summary plan description, and not only have one, but provide it to the participants and beneficiaries, as we discussed before, within 90 days of them going on the plan, and every 5 years thereafter, unless it's changed substantially before the 5 years. There must always be a named fiduciary. There must be a reasonable claims and appeals procedure. And there must be a fidelity bond to protect against dishonesty, unless the plan is funded solely by the general assets of the plan sponsor, which would be a self-insured plan, which I mentioned earlier. Okay, I also mentioned earlier that I recommend that you get used to thinking in terms of HIPAA as Part 7, because when we say Part 7, we're referring to a whole bunch of things, and like I said, it's an easy way to convey what you're talking about and have mutual understanding, hopefully, with the people in the conversation. So what are the health laws that we're referring to when we talk about Part 7 under ERISA, which are HIPAA laws? Or the HIPAA Part 7. The COBRA law, the Consolidated Omnibus Budget Reconciliation Act, but just keep it to COBRA. Everyone knows what you're talking about. Well, we will for sure, and hopefully other people who have responsibilities for group health plans. The Health Insurance Portability and Accountability Act, or HIPAA. In your slide, it says Mental Health Parity Act, but it has actually been amended, and it's now called the Mental Health Parity and Addiction Equity Act, MAPIA. There's the Newborns and Mothers Health Protection Act, we call it the Newborns Act. The Women's Health and Cancer Rights Act, we call it WICRA. Genetic Information Non-Discrimination Act, or GINA. Oh, it does say Mental Health Parity and Addiction Equity Act down there. Okay, the Children's Health Insurance Program Reauthorization Act, or CHIPRA, Michelle's Law, and the Patient Protection and Affordable Care Act, otherwise known as the Affordable Care Act, or ACA. And there are notices that are required for all of these health laws included in ERISA Part 7. And the publications that I have shared with you include that notices need to go out. And in some cases, there are model notices that you can put in your documents to share with participants and beneficiaries verbatim. Some notices employers or plan sponsors or plan administrators or fiduciaries get confused about. For instance, a COBRA notice needs to be individualized to the company, to that company's group health plan, and that company's cost. And then it also needs to be personalized to the circumstances of the employee that experienced a qualifying event causing you to send them a COBRA notice. For instance, their last day of employment, if that was the qualifying event, and the plan that they were under, and including dental if they were on the dental plan. We have some employers who are so confused about what they're supposed to do that they print out a blank COBRA notice on our website. They don't put any employer information or plan information on there, which of course is individualized to each employer, the cost, the plan, what's covered, etc. And they don't personalize it to the participant and the beneficiary in terms of this is how much your coverage was, this is how much it's going to be under COBRA, these are your options, this is when it's due based on the date of this COBRA notice. And so it's very important. You can't just print out every notice and send it verbatim. There are some that actually require modification, but we do have model notices. Under COBRA, you send out both a general notice and an election notice. And a lot of employers get confused about that or are not aware of that. The general notice, you can almost do verbatim, but you do have to personalize it to the employer. The election notice is when they've had something happen causing them to get a COBRA opportunity. And that's when you personalize it to the employer. Okay, so all of these health laws have notices that a fiduciary, that a plan administrator is responsible for. Okay, EBSA reporting and disclosure for group health plans. The reporting requirements. This is basically what you send to the government about your plans. Certain group health plans must file the annual report, which is the Form 5500. Disclosure requirements, which are things that need to go to the participants and the beneficiaries, what you're disclosing to them, notices, etc. Examples of some of the disclosure requirements, what we've talked about already, the summary plan description, the summary of material modifications. I hope this is sounding familiar. The summary of benefits and coverage. I mentioned that as the document where you do have to give advance notice in certain circumstances. Also, disclosure requirements would be adverse benefit determinations, which is what we call them, but the everyday nomenclature is a denial of a group health claim. We call it adverse benefit determination, but essentially it's really a denial. And other disclosures as required by EBSA 503 claims procedure rules. So you might recall a few minutes ago when I said one of the things required by the plan is that there be reasonable claims and appeals procedures. But those must comply with EBSA's claims procedure rules. And then, of course, the various notices to comply with the health laws of EBSA Part 7. And then COBRA notices, which we've talked about a little bit, and which I hope that you're already familiar with to some degree. That's the one that people are typically most familiar with before they have a talk with me. Penalties may be imposed for a breach of fiduciary duty. EBSA Section 502 imposes a 20% penalty on the amount paid pursuant to a court order or settlement agreement. The IRS can impose excise tax on prohibited transactions. I'm not going to go into very much into prohibited transactions. So I'm not going to go into them at all. They definitely are their own presentation. But there are certain things that are prohibited or should not happen or cannot happen or people can get in big trouble as fiduciaries. And I just want to put that out there. The IRS can impose excise tax under Internal Revenue Code Section 4980D for failure to meet certain group health plan requirements. And there are numerous other penalties for reporting and disclosure failures. One thing to keep in mind, and when we pursue investigations, sometimes a case may be civil and criminal. Sometimes it's just civil, sometimes it's just criminal, but sometimes it is criminal if there are certain facts involved in a situation, it can go criminal, and that's definitely, of course, a very serious set of circumstances with very serious also penalties. Some fiduciary breaches may also constitute criminal violations of ERISA, other federal law, or state law. Examples include accepting kickbacks, filing fraudulent claims, stealing premiums or contributions. And you know, the stealing the premiums or contributions, I was talking to a coworker yesterday, and some of these stealing situations are exorbitant, and you just don't feel bad for the person at all, because they're basically funding a lavish lifestyle instead of using the money coming out of their employees' paychecks for health insurance the way that it's supposed to be used to pay claims or to pay for the premiums or what have you. So some people are having these big lavish lifestyles. But sometimes it's a situation where the people are, the employer and the plan sponsors, they were not funding the premiums because they were trying to keep the business open because they wanted to make sure their employees had paychecks and jobs. And here they are up for criminal stealing when they had good intentions. They were just woefully ignorant. One of the things to always keep in mind that's very important is withheld contributions such as premiums for a group health plan are not business assets. Say, you know, we're low on cash flow, I couldn't pay the premiums because I was paying business expenses, I'll get the premiums caught up in a few months. That's simply not an option. They're not business assets. The employer has no discretion over doing anything other with those withholdings for group health plan premiums other than paying the group health plan premiums timely. And a lot of employers get confused about that, and then they get in very serious trouble as a result of that. But none of you will have that problem because you listened to my presentation today, and I made that point very clearly. So, okay, types of investigations that can occur. Investigations may be civil or criminal in nature and may focus on the plan or the plan sponsor or a service provider or an individual. And a service provider would be someone like maybe the insurance carrier might be a service provider. Or for COBRA purposes, sometimes people outsource that to a third-party administrator. But one of the things to keep in mind there is the employer is always on the hook for liability, even if they outsource those responsibilities to a third-party administrator. Excuse me. So sometimes we'll call an employer and we'll want to know what's going on or what are the provisions or can they assist with getting this COBRA notice. And sometimes we'll hear an employer say something like, I don't know about that. I hire someone else to take care of that. And the reality is, you might recall that I said earlier in this presentation that one of the requirements is that you must know and understand your plan and the responsibilities under it. The employer is always liable for what the service provider is supposed to do. So when we call to get the employer to help resolve an issue, it should be a big deal to the employer if their third-party administrator is not doing what they are supposed to do or hasn't in this case. Not only that, but you might recall me having said earlier in this presentation that there is a duty on the employer's part to monitor their service providers. So you have to make sure they're doing what they're supposed to do. And in order to do that, you have to understand what they're supposed to do and make sure that they're doing it. One of the situations that we sometimes see is here's an employer somewhere, hopefully in that employment arrangement of a corporation or a business, someone has an understanding of what's supposed to happen in different employee benefit law circumstances under ERISA. And there's service providers involved. Maybe a third-party administrator for COBRA, an insurance carrier. If it's a self-insured plan, maybe a third-party administrator to pay the claims. And the employer needs to know who all the service providers are and what they're supposed to do and make sure that they're actually doing it. sometimes there's a disconnect. The HR clerk is supposed to notify the COBRA third-party administrator that the employee no longer works there. And if that doesn't happen, there's a breakdown on what's supposed to happen, yet the employer has legal obligations for certain things to happen, such as a COBRA notice to be sent to the participant in a timely fashion. So not only the people that you hire specifically that are experts in COBRA, like the third-party administrator, or experts hopefully in your plan or insurance like the carrier, but the HR personnel, or whatever other personnel might be involved. Sometimes it's a very small business, and the HR person is also the accountant and is also the EAP, and sometimes wears many different hats, and they're kind of like, I can't remember the phrase that I'm trying to think of, but like a jack of all trades, but master of none. But these ERISA laws and obligations are pretty specific, and the requirements are pretty specific, and the penalties for not handling them properly can be significant. So you check out our website, check with your attorney, your accountant, whatever professionals you rely on, and then of course you can call a benefits advisor for certain things to get help. We don't go too deep in terms of helping people. Like someone wanted to send me their summary plan description so that I could look it over to make sure it's in compliance. I can't do that. That's when you hire an expert or an attorney or something to do that for you. Okay. The investigation may focus on an individual if they think that someone was stealing or an employer has been unduly enriched by keeping the premiums of the group health plan and not forwarding them on to whomever they're supposed to forward them on to, either the insurance carrier or the record keeper or what have you. We also do targeted investigations where we look for certain kinds of situations that are important for us to investigate or have become problem areas in the country regarding ERISA law, and so we're specifically looking for those kinds of cases. So places that we target for investigation possibilities are the participant complaints when they call a benefits advisor. Sometimes that becomes a referral to enforcement for an investigation. We look at Form 5500s, or investigators do. Review the Form 5500s to see if that's a situation that needs to be investigated. We get referrals from other agencies, state insurance departments, advocacy groups. We get referrals from the media, or we hear about something happening in the media with someone confessing or bragging about or disclosing that they're doing something in violation of ERISA, and that might be a situation that we need to look into further. And then sometimes private litigation lets us know about things that are happening that we need to get involved in, like the Enron debacle on the pension side. Examples of group health plan violations. These are ones that I hope will be accessible to you in terms of thinking, oh my gosh, I need to make sure we don't do that, or oh, we don't do that, do we? Failure to provide benefits in accordance with the plan terms. Improper or arbitrary claims adjudication. Failure to follow the Department of Labor claims procedure rules. Failure to forward employee premiums to the insurance provider. And I know I've kind of harped on that one and talked about it quite a bit, but that's probably one of the most prevalent situations that we have when participants call into us for help or complaints of what's happening with regard to their employer and their insurance. Failure to provide mental health benefits in parity with medical surgical benefits in accordance with the mental health parity rules. And failure to provide the required notices. The investigative process. The general process for civil plan investigations. We've identified a plan and an employer or a union that we're going to investigate, or that we might investigate. So we send an opening letter basically introducing ourselves and requesting documents to be able to look at what the plan rules are, how the plan is set up, see how it comports and complies with ERISA and notices and that kind of thing. The summary plan description, does it have everything that's supposed to be in it? Does it have stuff that's not supposed to be in it? And then we do interviews with the important parties related to the plan, maybe the fiduciary, the named fiduciary, the employer, the attorney, the accountant, whomever is relevant to that particular situation or investigation. Sometimes we have a voluntary compliance letter where we say, this is what we found, this is what we think you need to do, please voluntarily comply with the changes that we are requiring you to make, essentially, that you need to make to come into compliance. And then the correction hopefully occurs, and then we send a closing letter. Initial investigative steps. Determine the basic operations of the health plan. This is what the investigator will do. Is it fully insured or self-insured? Fully insured means that the claims are paid from a health insurance carrier that's contracted with the employer to do that. Self-insured means that the claims are paid out of the general assets of the employer. And there are definitely specific rules that apply to different plans. For instance, fully insured plans are covered by both state law and federal law, which is ERISA, which is what we have jurisdiction over. Self-insured plans are only covered by federal law, by federal ERISA health law. Other laws not related to health insurance could still apply to the employer or what have you. But self-insured, the Department of Labor, the federal U.S. Department of Labor, is the only entity that has jurisdiction over self-insured plans. We determine who the service providers are and what they do, what the contributions are, either by the employer or the employee, what the premiums are, the claims process and benefit payments in terms of making a claim to have a healthcare procedure or what have you visit paid, and how those benefits are being paid, or are they being paid? Are they being paid correctly? Are they being paid timely? Compliance with Part 7 of ERISA. There comes up Part 7 again, which is those various laws, the notice requirements of those laws. One, for example, that's a big one with us is the Mental Health Parity and Addiction Equity Act. That requires extremely complicated analysis to determine if it is to medical services. And so, but we can help determine parity, but the plan has to be in parity with those. Document, which is the underlying document under the summary plan description, the certificate of coverage, which shows the time frame of coverage that is issued to the participant once they no longer have coverage. The summary of benefits and coverage, which I've alluded to a few times. The distribution schedules, the documents related to plan finances, documents related to claims, participant notices required by ERISA, which is why some of those publications are very helpful for you to know in the vast array of notices that are required, what are they, how detailed are they, how easy are they, meaning can I copy it verbatim or do I have to personalize it, how frequently you send them, whether or not they can be taken care of by just simply including them in the summary plan description, are they an annual notice, etc. So those publications that I referred to before are very helpful with charts telling you this is what the notice is, this is when it's required. Sometimes here's an example of what you can do. This is who it goes to, this is when it goes. So I highly recommend having those publications as a resource for you. Participant notices required by ERISA, which is what I just said. Other documents related to ERISA compliance. Okay, now we are moving on to the fourth subject that we're covering today. And this publication that goes with this portion of the presentation, I did not put on the list because I just today decided that it would be an important one in some circumstances for people to have. But it's the name of the fourth presentation, the fourth section of the presentation. The publication is called Voluntary Fiduciary Correction Program. And it's a simple little pamphlet, but one of the important things that it has that is why I decided to go ahead and include it, but you'll want to write it down with the list of publications, is that there are certain transactions that can be included in the Voluntary Fiduciary Compliance Program. And there are 19 transactions that can be included, and it provides those transactions and acceptable methods for their correction. And so I thought, you know, that would be something that they probably might wonder about as a result of the presentation. I want to make that available to you. Okay, so for the fourth section and final section, we'll talk about the Voluntary Fiduciary Correction Program. Okay, now this is an extremely important point, very important slide, slide 33. Corrections have to be pre-investigation. So if you come to us first, you have noticed that you didn't do something properly, you didn't send out a notice, whatever you haven't done properly, if it's one of the 19 transactions, and you come to us and come to our Voluntary Fiduciary Correction Program and apply, then you're welcome to be a part of that program and allowed to get it fixed and taken care of. However, if we go to you first, like a benefits advisor calls you to resolve that the plan was canceled because the premiums haven't been paid for 4 months, if we come to you first, then you are not entitled to use the Voluntary Fiduciary Correction Program. If you get a letter, an introductory letter from an investigator, it's too late to use the program. We're already looking into investigating you or investigating you, and you have lost your ability to use that program. So if you catch something and know you didn't do it right, check the 19 transactions that can be covered and get it in there as soon as possible to make sure you come to us first and we're not coming to you first. Okay, that's a very important point. So I hope I made that clear and it sticks. Corrections pre-investigation. The Employee Benefit Security Administration encourages self-correction. Fiduciaries should regularly review their operations to make sure they're in compliance. In the first publication I told you about, it's Compliance Assistance Guide, Health Benefits Coverage Under Federal Law. This, if you get no other publication, this one is incredibly valuable. But it has, I think I mentioned earlier, it has a health law self-compliance tool where you can review what you're supposed to have and what you actually have. So I think I did mention that before. Very helpful, very important. So upon detection of not doing something properly, take corrective action. The correction guidance is in the VFCP documentation, and call us for compliance assistance. We have a person, an investigator designated to answer questions and provide assistance with the Voluntary Fiduciary Correction Program. However, correction during investigation. Often potential problems become clear during the investigation. If the problem is identified, work with EBSA to make corrections, even though you're not really part of the Voluntary Fiduciary Correction Program. Correction guidance may be available. Proof of correction and number of participants affected is required. Okay. Depending on the circumstances, appropriate corrective action may include a settlement agreement, notification to the participants and beneficiaries of the correction, implementation of new internal controls, re-adjudication of claims that were improperly originally adjudicated, paying unpaid claims, payment of the plan's administrative costs and expenses, interest, disgorgement of profits or a surcharge, penalties, removal of fiduciaries, removal of service providers, and appointment of an independent fiduciary. Criminal referral. This is where we either do a criminal case ourselves, but this would be a referral to like a U.S. attorney's office. an assistant U.S. attorney typically would take that case. If there are a situation of theft or embezzlement, healthcare fraud, kickbacks or bribes, false statements to investigators, so be very careful with what you say and that it's accurate, willful failures to file Form 5500s or false filings. The Voluntary Fiduciary Correction Program, VFCP, it's a self-help program. Correction methods are specified in the regulations. You must submit a complete application to the regional office. After everything's done properly, the way it's supposed to go with your application, the EBSA issues a no action letter, which is basically saying, you did it right, you're corrected, we're not going to do anything to you. Some transactions are eligible for excise tax relief. So one of the things to point out there may be penalties that need to be paid, or there may be interest that needs to be paid. So no action doesn't mean you don't have to do something to correct it or may have to pay for various things. It's just we're not going to take action against you. So sometimes you can get some kind of relief, excise tax relief, but very often you can't. The advantages of the Voluntary Fiduciary Correction Program: compliance with EBSA, guidance regarding correction, restoration of losses, increased benefits for some participants and beneficiaries, enhanced benefit security, more accurate valuations and reporting. Other advantages: the no action letter, avoiding investigation, avoiding an ERISA penalty, 20% penalty on settlement agreements, avoid potential litigation. You can avoid an excise tax sometimes. The VFCP process: you identify potential ERISA violations that you have, determine if you are eligible as one of those 19 transactions, correct the violations, follow the formula to do so in the VFCP, calculate and restore any losses, make other corrections if needed, make supplemental distributions when appropriate, and file an application with our regional office. The VFCP process is designed to be a voluntary program, no need to consult with EBSA, and you apply after the correction. Eligibility requirements: neither plan nor applicant can already be under investigation. There can be no evidence of criminal violations, and EBSA has not referred the transaction to the IRS, where the EBSA has notified the plan official of the referral. Corrections: all losses must be restored to the plan, all prohibited transactions corrected, all valuations must be based on, and I'll just gloss over that because it's something else. Supplemental distributions must be made. No correction costs paid by the plan. 5500s must be amended when appropriate. The correction amount varies based on the transaction type. There's details in the VFCP program. Correction amount usually includes not only the principal amount, but the amounts that would have been available for investment or distribution but for the breach, original transaction costs, plus the greater of lost earnings or restoration of process. VFCP transactions: not all fiduciary violations are included, must be one of the 19 described transactions. The limits: the relief is only afforded to applicants. We reserve the right to investigate truthfulness, completeness of the application, confirm that correction actually occurred, refer any criminal information to the appropriate agency, take other actions under special circumstances. The relief: you get the no action letter, limited to transactions at issue, limited to corrections at issue, no approval of prospective corrections. It's conditioned on the application's truthfulness, completeness, accuracy, but does not limit the rights of other parties. There's annual report filings, amended Form 5500s for previously unreported prohibited transactions or revalued asset situations. Filing an amended Form 5500 does not trigger ERISA penalties. VFCP payments: payments for missing individuals. Don't wait until found to file the application. Provide a statement that their benefits have been set aside and that the plan is looking for them. De minimis distributions: if less than $20 and distribution cost is more than the benefit, reallocate the amounts to other participants and beneficiaries. Okay, resources. For private sector group health plans, For information about COBRA, ERISA, or HIPAA, call us at the toll-free number. You'll talk to a benefits advisor like me. Our website's on there again. If it's for the Family Medical Leave Act, FMLA, then you would call the Wage and Hour Division of the U.S. Department of Labor, which is a sister agency to us. Other resources, and it's basically EBSA publications that you might find helpful. And we have health benefits education campaign seminar series, but it's rare that it's in Kansas City. We do have one this year, but it's in Minnesota. Okay, and I believe we are done on time. And at this point, I would be happy to entertain questions. And like Natalie said before, if it's like unique or specific to a particular employer situation, then that might warrant a call with a benefits advisor. But for general questions about what we talked about today, I would be happy to take questions. And if I understand it correctly, you have submitted questions in writing through the webinar, and then Natalie's going to read the questions to me. Did I get that right, Natalie?
Yes, that's correct. And I think we have maybe one that Alex is going to read. Yeah, so the one question we have so far is about corrections. The question is, are those for the past year or for how long?
I don't know how long the corrections can go back. I don't know if there is a limit on that. Like I said, we refer all the questions related to the Voluntary Fiduciary Correction Program to our person who handles that, which is Liz Nichols. But if you want to give me a call and reference that your question came up in this presentation and give me your name and number, I can send you to Liz Nichols to answer that question. I'm sorry, I don't know how far back they can go. The correction can go.
All right, thank you. And right now I don't have any other questions. We'll leave it open for just a couple more minutes. The Q&A button should be in the top left of your screen. You just type in your question there and it shows up here for us. Oh, shoot. We might have another one here if I can get to it. Here's a question. In regards to filing 5500s, are all employers required to file 5500 or only employers with 50 or more employees?
Let's see, let me look at the report guide. Not all employers, well, it depends on the group, it depends on the plan. Some small employers do not have to file 5500s in certain circumstances. Some small health plans don't have to file 5500s in certain circumstances. In terms of the size, let me look and double check. And it's bringing me to the pension section, so that's not good. Here we go. There's a short form that's available for certain employers with welfare benefit plans, which would be the group health plan. And I'm trying to see what that number is to qualify it as a small plan. I thought it was under 100, but if he or she is saying it's 50, that's making me question myself. Here we go. Pension plans and welfare plans with fewer than 100 participants at the beginning of the plan year that are not exempt from filing an annual return report may be eligible to file the Form 5500 SF, a simplified report. So yeah, that's 100.
Well, thank you, everyone. That's all the questions we have. So thank you, Kathy, for joining us and leading through this topic today. Again, Kathy can be reached with any follow-up questions, and we hope everyone has a great day.
There's one other thing. Can I go ahead and say one other thing?
Yeah, of course.
I hope I said this, but I'm not sure. If you want copies of the publications, Did I say this already? Reference this presentation and email me with your name, company name, address, phone number, name of the publications you want, and we will send those to you. Thank you.
Thank you.
I appreciate it.
Thanks, Kathy. Have a great day.
Thanks, you too.